Thank you. Thank you so much. It's a pleasure to be here in Amsterdam at the summit for my first time here, actually. I was at the London summit in June, but this is on a completely different scale, so thank you to everyone. My name, as you know, is Rachel Muldoon. I'm a barrister based in London. Now, barristers don't typically leave libraries unless they go to court and stick the wig on. I'm a bit unusual in the sense that my practice as a barrister, as a lawyer, is to assist the technology industry. My clients, ranging from retail to distributors to you name it, everyday brands. I can't do that unless I know how the industry works, and at least a bare overview of how the technology works. So I defer to you guys on that. You're the experts, and I'm the expert on the legal aspect, and we need to work together and be a team. So that's a bit about me. Increasingly, in the past 3 years, I've been advising my clients on preparedness for the inevitable changes that will come into force across the globe in terms of the law and AI, in particular, generative AI. So this year has been very much a focus on the EU's AI Act, so that's draft regulations, as many of you will be aware, and you would have seen bipartisan support in the US for an AI legal framework, a generative one. You've also maybe heard about the UK, which I'm not a big fan of in terms of the approach. I think it's fundamentally wrong, saying principles will be enough. But certainly, come the 1st of November, in less than a month, there will be an AI safety summit. So a lot of change on the horizon. So in the next 20 minutes, I want to achieve 2 things. The first is I want to give you an overview, not legalistic, but a human, and we'll come back to that word, overview of how copyright law interacts with generative AI. The second thing I want to do is offer you my predictions as to the future, the legal treatment of generative AI and where the pinch points are and what you can do now, or really yesterday, but let's just say now. The focus will predominantly be upon 3 areas of law, jurisdictions, the US, the EU, and the UK. So a lot to fit in the next 15 minutes with 5 minutes for questions, but I'll do my best. The usual caveat applies. Nothing I say today is to be construed as legal advice. If in doubt, always seek. I'm seeing some smiles from the audience. I have to do this, sorry guys, but always seek independent legal advice because legal advice will depend upon your circumstances. Now, before we begin, everyone take a moment. It's been a long day. Let's take a deep breath. I want you to cast your mind back. Think about a time when you were really proud of yourself. That thing you hold on to before you step on a stage like this, or before you walk into a board meeting or meet with a client. Think about that one time that you created something. Anything. Could be a work of art, a performance, a report, a poem, a recipe, you name it, but feel that pride in your creative endeavor. We'll revisit that in a bit. Now, broadly speaking, we know that generative AI models are trained on inputs and generate outputs, typically in response to given prompts. The question here I want to ask is, who in the audience works in the legal sector? There's not many of us, guys. Where are they all? Come on. You need to engage with industry. But congratulations for coming here today with a few. For those of you who don't, copyright is something we call the type of intellectual property, okay? It looks to protect creators of original works. That can be a multitude of things. A work can be art, it can be written, or it can be otherwise. Now, these creators also referred to as copyright holders, but then again, someone may create something, then license it to someone else, or assign it completely in terms of title and all the rights. But what does copyright actually do? Copyright really is the ability to restrict and control. It's the ability to control how your creation or the work that you've come into possession of in terms of rights, how that's reproduced, how it's distributed. Think of the quintessential examples of trade secrets, like the secret ingredient to Coca-Cola. It's separate from a physical, tangible object. It's the right to control that property, okay? Now, as we've heard in sessions before, IP, copyright, vests in humans in the legal sense. Now, a legal person can be an individual like you and me, or it can be a corporate, okay? So essentially a group of humans. The key then is, what do you do when that right is infringed? And this is what I want to hone in on, the tension. The tension that all of us in this room, looking at industry, looking at developments in technology, are going to see more and more of in the coming days, weeks, months. I would give that much time. We know that in order to arrive at high-quality outputs, generative AIs must rely on high-quality inputs. That much is clear. But volume. Volume is, I'm instructed, key. Okay? These models rely on huge quantities of data. They're nearly always derived from open source information, or OSINT, as we call it in the intelligence field. And this can very often encompass the data set, copyright-protected work. That is the tension we have, that we have the development of technology on the one hand that's reliant upon essentially infringing the right to protection of human creativity. And on the other hand, the creators saying, well, up until now, our creative human endeavor has been protected in law. So where do we stand? How do we navigate this? So it's often said that it's a necessity to train these models on these large volumes of data. It's entirely unworkable to obtain consent from each copyright holder in terms of, can I use this data? But the issue is the indiscriminate nature of the scraping. And what do I mean by that? Well, these models, essentially, not all, but many, are seeking to sweep large swathes of data from open source without considering really two things. One, whether in fact those data sets contain protected works. And the second, well, do I need to obtain consent or remunerate the creator or the copyright holder for that? We've just been rushing ahead without pausing. So this poses a whole host of legal issues at various junctures. You have data protection issues, privacy issues, but today we focus on copyright. Now, the billion-dollar question, is this practice defensible in law? Or are you, as producers of generative AIs or distributors or otherwise looking at the EU's Act and other frameworks, are you going to be in court sometime soon with me either on the other side or fighting your corner? Because I'm afraid there will be those of you in the room who will find yourselves in that situation, I'm afraid. And that is the harsh reality. Not because I want the work, far from it, but because that is the shift that is going to happen. There is going to have to be the law stepping in and asserting rights. So compounding this, there's no harmonization in terms of copyright law. So across the various jurisdictions, there's differing approaches to how copyrights are protected. There's therefore uncertainty. And yet one thing is consistent, as I've just alluded to. The world over, there has been an influx of lawsuits filed against generative AI producers. Now, you'll be familiar with many of them, but for one example, let's look at this. Where I'm based, of course, in the UK, we've had Getty Images file a lawsuit against Stability AI. This concerns the alleged unauthorized use of works, copyright-protected works, to the tune of 12 million photographs, it's alleged, captions and metadata, used for the purpose of Stable Diffusion's training and outputs. Now, how do we navigate the choppy waters that are to come in terms of this legal minefield of liability? How do we navigate this? Well, let's first turn to explore really how the defenses arise. Well, how can I defend what I'm doing with this generative AI? Let's start first with the US. Now, caveat, I'm not a US attorney. I work with many attorneys there, but I can certainly speak to parallels with the UK and the EU. Much has been said about the US fair use defense. Fair use allows persons other than the copyright owner to make certain limited use of copyright-protected works without the owner's permission. It's based on a concept under US copyright law that it's facts, ideas, and styles that fall outside of the need for protection. That doesn't need protecting. Instead, it's expression. How does a human express that particular idea or fact? Now, whether or not that defense applies is, of course, a matter to be determined on a case-by-case basis according to the facts, often by the courts. The US courts are familiar, of course, with examining whether the making of copies or copyright-protected works are lawful. They have looked at, for instance, temporary copies of copyrighted works with peer-to-peer sharing of documents, and the seminal case in 2007 of Perfect 10 and Amazon, I should say versus Amazon, if I use the US terminology, where the US Court of Appeal considered whether Google's making of thumbnail copies of copyrighted works amounted to copyright infringement. And there was a key word in the judgment: transformation. The court held it was transformative what Google had done in creating a thumbnail of the photos in question. And it was transformative because the purpose had changed. The thumbnail served an informational or a presentational purpose. It wasn't creative or expressive per se, as the photographer had intended in relation to the underlying work. Now, some of those have said that the same should apply to generative AIs, because there's nothing expressive about what a system is doing or a model is doing. And supporters say there are compelling reasons for applying this defense under US law to generative AIs. It's a necessity, as I've said, for the development of machine learning for these large volumes of inputs. A licensing regime, it is said, would be unworkable. And thirdly, the volume of data actually assists society in mitigating against bias, as we heard in the last session. But let's just be clear. No US court, I'm ready to be stand corrected, but no US court I've found has actually applied this defense to generative AIs yet. Now, running with this idea, many think we need to reframe the defense not as fair use, but fair learning. And this would essentially be a defense to provide a blanket exemption for the use of copyright inputs. It would mean that so long as the purpose of copying the work is to facilitate the training of machine learning models, then there's a legal presumption that it's fair. No other questions asked. But does this all add up, legally speaking? With respect, in my view, it doesn't. Fair use defense is predicated on transformation, as we say, transformation of purpose. That is to say, a different purpose from the original creator. I do not consider it likely, but I'm happy to engage in debate, that legislators or judges would consider all outputs to be transformative. Applying Perfect 10, this would require all outputs to be merely informational and presentational. It really hones down to this one example. Let's take that of an image of the Eiffel Tower. It may be that a system inputs this, or it's input into a system rather, to learn about the factual features of the Eiffel Tower, its shape, for instance, or classify it. That may suffice for the defense. However, many systems do more than this, of course, and let's face it, generative AIs have captured the public's attention because of the fact that they mimic human behavior when it comes to advanced levels of machine learning. It's that mimicry of creativity that paradoxically may undermine this defense because you have an expressive purpose. So there's the tension here. The machine, as it becomes more human, actually can't satisfy the human defenses in law, and there lies the irony. So, I'm mindful of the time, let's keep moving on and ploughing through the law. Now, the court has not yet analysed also the journey that copyright-protected works actually undertake, because they're analysed again and again as part of the machine learning stages, and then the replication and duplication. Again, going back to Perfect 10, that simply didn't apply when it came to Google's use of the thumbnails. That was a one-time replication. So again, the courts are going to have to grapple with the process and the purpose in tandem. Therefore, I consider it unlikely that the defence, at this stage at least, as it stands under US law, will afford any protections to those of you in the room who are involved with the US market. Briefly on the EU, under EU copyright law, you have an exemption, really, for the purposes of text and data mining, or TDM. And this is where works input are lawfully accessible, they're out to use without consent, but the copyright owner has not expressly reserved their rights. Therefore, if you haven't obtained consent, but they provide that their works aren't to be used, whether by a watermark, metadata, or otherwise, then this isn't a defense for you. And so it's by no means a blanket exemption. Against this backdrop, we also have the new Draft AI Act, which imposes disclosure obligations, and there are more complications because, of course, copyright differs from member state to member state. And unlike the US, you don't have a copyright register. Finally, on the UK, the concept of fair use does exist, but in very limited circumstances. You have non-commercial research, you have private study, criticism, review, parody, pastiche. And therefore, if we look at TDM and also the concept of temporary copies, neither defense will apply in a commercial context. So again, you're on your own, I'm afraid. So what does this all mean for us? Well, the fact of the matter is, there exists no one defense in law. There's no silver bullet that is going to protect you. When you bring your product to market, I'm highly, highly doubtful that fair use is going to protect producers. That's just my view. I'm ready to be stand corrected. The law will change. The courts will become more familiar with processes, and there will be that balancing act. But you'll remember that at the beginning of this talk, I invited you to cast your mind back to a time when you felt pride in something you created. Now imagine a world where that work isn't protected in any way, but a machine's is. Thank you.
Thanks, Rachel. I think we have time for one question. Anyone from the audience would like to ask Rachel something?
I've confused the room.
No, I'm super clear. Yeah, right here.
Hi, Rachel. Thank you for that. Can you elaborate a little bit? So you talked about using protected content, intellectual property, as an input into the training of generative algorithms.
Yeah.
Can you talk about the interface with personal data, so a different variety of protection, when that gets integrated into generative models and then gets reproduced by them? What are the issues raised there?
Oh, goodness. Well, hopefully I can speak on this next year. But so at the moment, I have 8 class actions looking at data protection breaches in the generative AI space. If we're looking under, say, GDPR, key starting point is Article 25. That provides that you need to have systems in place by design and default, basically integrated in your business. And that needs to protect personal data. Now, of course, we have the possibility of anonymization. So, for instance, personal data, names, addresses, contact details can be anonymized, so you can't trace them back to me. But that will only take you so far. The key is really anonymization and also human intervention. Again, the law requires that human element. You can't purely have algorithmic decision-making without the involvement of a human being. And so, yeah, anyone wants to chat about that? I'll speak to you after the session. I'll be here all day, and I'll be at the EY boat cruise tonight. Let's grab a drink.
Awesome. Thanks, Rachel.
Thanks.